Many questions here. Attorney Mark Geragos represented Peterson at trial. He joins us now live on this broadcast. Attorney Geragos, thanks for joining us.
Thank you. Good afternoon.
Good to see you here. Peterson filed this petition for habeas corpus in 2015, and the state court disagreed with 18 of the 19 claims. So this is primarily just a dispute about the juror who failed to disclose that she once feared for the life of her own unborn child because her boyfriend's ex-girlfriend was harassing her. What was your fear during trial? Was your fear that that juror might sympathize too closely with victim Laci Peterson, or was it just a fear that that juror lied during voir dire?
Well, look, this is what had happened. The Supreme Court first, as you talked about in the setup piece, just reversed the death penalty. So they have the option now of retrying the penalty phase. But before they got to that or made a decision, they now have issued what's called an OSC, order to show cause, to the trial court as to why the conviction should not be set aside. And you aptly put, they specifically honed in on this one issue, and this issue is a significant issue. We complained in real time 20 years ago that we kept exposing or finding what I called at the time stealth jurors, meaning jurors who were lying and had an agenda to get on here. And frankly, every single one that we identified was lying to get on here to convict him. We caught a couple of them in real time. This juror, we did not. But I was not as concerned about her at least when she was an alternate. When she, after the judge pulled off and eliminated a couple of jurors who had indicated that they were hung, she was placed into the jury, and she is obviously a troubled young woman. And the subsequent investigation showed that when she filled out the forms, she had absolutely lied about the fact that she had had a restraining order and that she had had an encounter with another woman. And that was exactly what another juror who we had found and exposed during voir dire had done. And then later, that other juror had admitted that she was lying to get on there to fry Scott. Her words, fry Scott. So this is a significant issue. Obviously, I've maintained for close to 17 years that Scott is innocent and that this was a mob verdict. And hopefully now he'll get the justice he deserves.
So the core of the case here, though, appears to be intact. You know, all of these other points that were raised during this specific appeal, issues about whether or not the state improperly presented evidence about the growth of the unborn child, about the dog scent, about exactly where the bodies were alleged to have been placed in the water, about your own defense strategy, and these questions about whether Laci was seen by other people walking the dog after Scott went to go fishing. Those questions, the appeals court turned around and said, we apparently don't have a big issue with those. So is the core state's case strong enough here? Because it appears that remains intact.
Well, it doesn't really matter at this point. If they find that she had committed the error that they've already found, which is an OSC, means there's basically probable cause, prima facie. You've made a case out that there was prejudicial effect or conduct. If that's the case, none of that other stuff matters because you have to set aside the conviction. So we can argue about the other stuff, and frankly, that will probably end up in the federal court if this doesn't gain traction. But it's already gained traction. I think that, frankly, what's happening here is that the Cal Supreme knows exactly what they're doing. They had said, remember, the exact reason that they said they reversed the death penalty is because the prosecution had sat back and let the judge, over our objections at trial, seat jurors who were pro-prosecution, who were pro-death penalty, and had eliminated all jurors who said that they had issues with the death penalty. My argument has always been, if that's the case and that's the law, and clearly it is the law from the U.S. Supreme Court to the California Supreme Court, how does a juror who is pro-prosecution for the penalty phase, not pro-prosecution for the guilt phase? Well, now we're going to find out, because if this juror did commit what it appears she did do, then the verdict itself is tainted and must be thrown out.
Biased jurors are a huge concern. I have seen judges in other cases we have covered here turn around and claw a verdict back and say we've got to start from scratch because of an issue with a juror. It happened in the Shayna Hubers case in northern Kentucky near Cincinnati, for instance. And that was another high-profile case where this was an issue, slightly different issue, but it's happened. So, okay, what does it mean if your former client gets a new trial? How does that play out?
What it means, and if you play it out, there's no way they convict him. I just don't believe that's going to happen. I mean, people can talk about he's guilty, he's guilty, he's guilty. The fact is, nobody knows or knew that evidence better than our team did in real time. And there wasn't a single person on the team who didn't feel as if there was a complete collapse of any evidence. By the way, including the trial judge at various times during this case. And so there is no, to my mind, justice that has been for Lacey, for Scott, for Connor, or for either of the families.
Attorney Mark Geragos, appreciate you joining us here on Law and Crime Daily for the insight. You were there for it. You know it perhaps better than anybody else.
Thank you very much. I appreciate it.
I want to switch now very quickly to Terry Austin in Eklund Mercy, a criminal defense attorney in Atlanta, Georgia, who's also joining us. Terry, real quick here, your thoughts on this. Does this case deserve to go to get a new trial based on what we know about this juror?
Well, you know, the interesting thing about this juror is she might have been asked, were you involved in other court proceedings or a lawsuit? And she may not have understood that the restraining order is a court proceeding. Actually, it really doesn't matter what her understanding was. If in fact she did not answer that question correctly, it could very well be a legitimate reason for sending this back to the trial.
And Attorney Eklund Mercy, your thoughts very quickly.
I think once a case has at least 2 made-for-TV movies, that an appeal was going to be granted at some time. Like, you knew this was going to happen. It was like one of the biggest cases. Everybody wanted to be on that jury. It doesn't surprise me that this came up.